My name is Jeff Steinle. I'm an attorney with Fredrikson Byron. Today we'll discuss 6 reasons that artificial intelligence differentiates digital health from traditional med tech. I'm a corporate and mergers and acquisitions attorney at Fredrikson. I'm in their life sciences and healthcare group. I am also part of Fredrikson's integrated artificial intelligence team that offers legal services to companies that are applying AI to their businesses. So artificial intelligence, what is it? So artificial intelligence does effectively 4 things across various industries. First, it gives us better access to information. These are companies like Google and others that have significant databases of information. They connect us, companies like Snapchat, LinkedIn, Facebook, and others connect us through our phones and our devices that we carry with us all the time. Artificial intelligence helps us know our preferences. These are companies that create the pop-ups when you read the New York Times or shop on Amazon that know what we like. And they also keep us in our lane. At the base of all of these technologies is really algorithms and processing power that's fueled by data. As it applies to digital health, we also see this as well. So digital health uses these same artificial intelligence principles and applies it to healthcare. We can categorize digital health into a number of different areas, such as consumer apps and wearables. These are devices like Fitbit, health IT and services. These are the systems that make our physicians more efficient and make our hospitals run better. Telemedicine, which offers the ability for patients to see their physicians from remote locations without having an office visit. Automation and robotics. These are companies that will use robotics to perform surgery and automation to better identify surgical sites and increase the efficiency of patient procedures. We see artificial intelligence used in clinical research, where previously it was a manual and cumbersome process to develop the clinical research and the clinical study. Now we have vast troves of data that can be used to better identify new technologies that can help patients. We see connected devices and Internet of Things or IoT devices that are used in healthcare. And finally, we have medical algorithms that help doctors better analyze data that they have in front of them and further develop patient care. Digital health funding has continued to increase over the last several years, with a 2001 level of about $1.2 billion, going up to roughly $4 to $5 billion over the last couple of years. And we anticipate that it will continue to increase as we move forward. So the question is, why is it new or different from traditional med tech? And the sub-question is, why hasn't digital health moved as fast as other industries in capitalizing on sensors, data, and processing power? And this will be the key to what I'll talk about over my talk here and what I've seen through my own clients and from observing the industry. The first reason I think it's different from traditional med tech or a med device world where I grew up is that there's really a different business model at play here as compared to what we've seen before. Traditional med tech would look at fee-for-service based models, reimbursement that would reward effectively more and in some more advanced but also more expensive healthcare solutions. Digital health instead really has a focus on value-based healthcare. The reimbursement model for digital health is also better suited for gain sharing or reimbursement schemes that help providers benefit from lowering costs as opposed to those traditional fee-for-service or fee-for-products services. That risk shift in gain sharing also shifts risk of payment from the providers to the providers from payers. And the last one is that as a result of this, there's also more application from the shift from product launches from companies that are more reimbursement based, like the US with Medicare, to more cost focused markets. These are private pay hospitals and emerging markets and other places where cost is really more of a focus than it is in the US, Europe, or Japan. The second reason why it's different is that software is regulated as a device, and software as a somewhat amorphous, somewhat less tangible product is more difficult for the FDA to determine. This is particularly applicable as artificial intelligence and machine learning will modify software as it goes through. So the first baseline is that software is regulated and goes through an approval process, either a PMA or a 510K for medical devices, like a device does. But the FDA recently has really taken a look at what they're going to regulate and what they're not going to regulate. So the FDA may not enforce regulatory requirements for minimal risk, quote unquote, devices that are really software. But as that software improves over time or moves into more high-risk areas, there is more of a necessity and more of a likelihood that the FDA will regulate it. As a result of that, it's very important that the quality program for the coding and development process is really starts very early in the process so that we can trace back the development of that code all the way from the very beginning of the development. The FDA continues to wrestle with these issues and what the submissions are based on the updates to software and machine learning. So we'll continue to see additional information as we go from there. At this point, they have issued guidelines regarding post-market surveillance and risk assessment, and they've also issued risk-based guidelines for interoperability as it relates to how devices interact with the digital platforms. The third reason why I see digital health and artificial intelligence as it applies to healthcare being different from a traditional med tech or pharma or medical device world is in the area of intellectual property. So Chuck Siegelbaum of our group will also talk on this topic as well. But I think it's important to note, first and foremost, that what I see many of my clients doing is really relying more on trade secrets as opposed to patents. The reason for this is a couple of things. First of all, the Alice Corp case and its progeny has really spurred a change in the view of how patents are used for software. I'll let Chuck speak in more detail about Alice, but the baseline or the way I think about it as more of a corporate or M&A lawyer is that for software to have a patent, you really have to have an output or something tangible as a result of that software, as opposed to simply doing the basic math or the basic algorithm that you could otherwise do manually being done by a computer. The result of that is that some algorithms can be developed to have patent protection, and others you are better served if you rely on trade secrets instead. The second reason is that the technology changes really rapidly in this space, and the patent process continues to move fairly slowly. So as a result of that, by the time you get your patent issued, the technology may be old and it may not be as useful for you, and you may have moved past it at the same time that you have patent protection. Last reason is that there's really a difficulty in reverse engineering some of these trade secrets. So if you're able to keep them secret, it's not like a medical device where you can take it to a benchtop, take it apart, and determine what is inside of it and redevelop it. The algorithms are sometimes based in code. They're in locked devices or locked software programs that are very difficult to determine what the actual algorithm or what the math is as a result of that. So trade secrets in many cases can be more useful for AI and digital health than patents are. The second thing, and one of my client CEOs has repeated this often, is that data sometimes is viewed as the new IP. So the thought here, and many of the commentators have said this as well, is that as we move forward with artificial intelligence, that companies will argue over ownership of data, the use of that data, and tracking how that data was used to develop their IP as they move forward. The last reason that intellectual property is treated a bit differently in digital health than it is in traditional medical technology is that the number of folks with these artificial intelligence skills is very limited. As a result, there's somewhat of a fight over who has these folks working for them. And with a limited number of folks who have the skills to be able to develop and apply the artificial intelligence to the technology, that creates a demand for this. So rather than having a patent or having traditional IP that you license and others can apply, you really need the folks with the skill sets to be able to both develop the artificial intelligence as well as to further embody it into the technology that you've developed. Reason number 4, I think, is that digital health is different than traditional medical device or medical technology, is that the players are different. And I see this a lot as a mergers and acquisitions lawyer, in that when I first started doing medical device deals, we would see a limited number of traditional med tech players like Medtronic, Abbott, Boston Scientific, J&J, and perhaps a couple of others that would really bid on a limited number of new technologies and startup companies to roll out and market their devices. In digital health, we have that group of players, and we also have tech companies like Google, Apple, Amazon, and Samsung that are looking at healthcare as a way to increase their market shares and further drive growth. The other thing that we've seen is a fair amount of spin-outs, divisions, and joint ventures like Verily, Verb, and Galvani. And the payers are increasingly becoming active in this space as well, like Optum, the Blue Cross Blue Shields, and Aetna as well. Healthcare organizations continue to look at digital health to further drive down costs and increase patient care. The Mayo Clinic, Texas Medical Center, and Cleveland Clinic are all actively involved, as well as other large healthcare organizations throughout the country. And we continue to have a very active startup community with smaller, purpose-driven new companies that are either looking for an exit or would like to support these larger companies with a data play or a digital health play or the like. In addition to the players doing the deals, I've seen the types of transactions and the types of deals being different as well. I think the reason for this is that there's a heightened need for collaboration across these different players. Certain companies and certain players in this space have the access to the patients, others have access to the data, and together they end up doing deals together that combine those into developing new products for patients in the healthcare space. We've seen a handful of these, Verily and GlaxoSmithKline combined to form Galvani. Medtronic recently announced a transaction with Amwell for a telemedicine play. United Healthcare, one of the largest healthcare insurance companies in the country, has created a joint venture with Inovalon, who drives data-driven algorithms and solutions. And we also see other players who are doing acquisitions in this space. Murata, which is one of the largest electronics components manufacturers in the world, recently bought Vios Medical. One of my clients, Vios, who has a Internet of Things based sensor and vital signs monitor. The other types of deals that we see data sharing arrangements, they do joint ventures, there's licensing, and of course the roll-up of smaller companies like the Murata and Vios transaction that I mentioned. The last reason that I'll cover briefly, and Sten Hoidel from our firm will talk about cybersecurity across artificial intelligence more broadly. We see this particularly in healthcare. And the reason why this is a huge issue in healthcare is that there's significant regulatory risks and significant bad actor risks because patient health and privacy is at stake in these areas. We've seen a fairly dramatic increase in settlements on the regulatory side with HIPAA settlements. I throw out the CardioNet example, which was a $23 million settlement in 2016. And we've seen fines for stolen laptops, we've seen product recalls, and we've seen warning letters over potential cybersecurity risks in the medical device space. Why is this? I think that there are a number of bad actor risks that are particularly applicable to medical technology. First, medical records have value to hackers. These records can be sold online, both for an identity theft as well as for potentially for ransoming the healthcare providers that have access to them. They can be used to apply for loans and credit cards. They can be used to make false claims against insurance companies or to compromise existing patient financial accounts. There does remain the threat of direct threats to patients through shutting off their devices if they can be hacked into. And we have seen over this past summer a couple of worms that infiltrated hospital systems and were able to spread to medical devices. For cybersecurity, and again, Sten will talk about this in more detail, but the question is, what can you do practically? There's a handful of things that we look at, and as a contract and corporate and M&A lawyer, I look at these in terms of what we're requiring our counterparts to do, and here's a handful of them. First, incorporate cybersecurity into the design of your device. Second, hire cyber experts, both inside or outside of the organization, to assess risk. Number three, and I have a good friend who's in the cybersecurity business who will always state this, that cybersecurity is more of a people problem rather than a technology problem. So focus on the people, the training, and not just on the systems. Number four, the financial sector is much further along in this than the digital health industry is. Look to them as a model for what they've done and how they've been effective in maintaining the security of their financial accounts. Next, work with your customers and make sure you understand what their needs are. Also, it's very important to know the regulatory framework, which can change from geography to geography around the globe. And finally, in all the contracts that you draft, make sure that cybersecurity and that risk allocation between the two parties is identified in the contract and very clear. I'll close with one quote that came out from Marion Webb, who was reported on Ernst & Young's annual MedTech report last year. Marion said that only those companies willing to embrace innovative technologies such as artificial intelligence will come out as winners, as she commented on digital health. We certainly believe that's true at Fredrikson and remain happy to help our clients who are wrapping artificial intelligence into their businesses. If you have any additional questions or would like to reach out, you can reach me at jsteinle@fredlaw.com, and I can connect you with the appropriate colleague, one of my colleagues, to make sure that we get your questions answered.